attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the recent SEC investigation, report, and public statements related to initial cryptocurrency offerings, or ICOs. On July 25, 2017, the SEC issued its report on an investigation into the ICO by the DAO, an unincorporated entity, Slock.it, a German organization, and various principals and participants in the offering. Previously in this Lawcast series, I went through the parameters of the Howey Test to determine if a particular investment contract is a security under the federal securities laws, and applied that analysis to the DAO and its ICO offering facts. Upon concluding that the DAO tokens were securities, the SEC also concluded that the DAO needed to register their issuance or satisfy a registration exemption, regardless of whether the DAO was incorporated or an unincorporated organization. Issuers, like securities, are broadly defined to include any sponsor or organization that is primarily responsible for the success or failure of a venture. Participants in an offering are also subject to Section 5 obligations. Section 5 is the registration obligations and concurrent liability. Accordingly, this included the Slock.it founders and principals in the offering. The secondary trading platforms also required registration or the availability of an exemption under the federal securities laws. Section 5 of the Exchange Act makes it unlawful for any broker, dealer, or exchange to directly or indirectly affect any transaction in a security or report such transactions unless the exchange is registered on a national exchange or exempted from such registration. Section 3A1 of the Exchange Act defines an exchange as any organization, association, or group of persons, whether incorporated or unincorporated, which constitutes, maintains, or provides a marketplace or facilities for bringing together purchasers and sellers of securities, or for otherwise performing with respect to securities the functions commonly performed by a stock exchange, as that term is generally understood. The functions of a stock exchange generally include bringing together orders for securities of multiple buyers and sellers, and using established non-discretionary methods under which such order contracts interact with each other, and the buyers and sellers entering into such orders agree to the terms of that trade. A frequent exemption to the definition of an exchange is an alternative trading system, ATS, which complies with Regulation ATS. Regulation ATS requires, among others, registration as a broker-dealer. The OTC markets, for example, is an ATS, as is TO Technologies. The platforms that traded the DAO tokens fit within the definition of an exchange and did not satisfy any available registration exemptions. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.